The North Gauteng High Court has ruled that load shedding is a violation of human rights and directed Power Minister Dr. Newzroom to guarantee that public hospitals, public clinics, public schools and police stations are not disrupted. We speak now to the UDM's General Secretary Yongama Zigebe. Thank you very much, sir, for your time this afternoon. So the party had initially approached the court seeking relief on two parts. Part A, we believe that that application saw the court granting a number of orders on the 5th of May 2023. We'll get into Part B, which was abandoned in a few moments, but how should we understand this ruling and your contribution?
Thank you very much for having us. This ruling is a ruling that vindicates the United Democratic Movement, and it's a win for the people of South Africa, especially in the sectors that there have been ordered, such as schools, police stations, hospitals, because you'd remember that at some time, beginning of the year and even last year, there were protests that are happening in Queenstown, in East London and other parts of the country, where people have been protesting that their people are dying in hospitals because there is no provision of electricity, and that hospitals, they do not have an alternative source of energy. So we saw as a UDM that this is a time that we cannot, humanly watch what is happening in the country and people dying just because this man-made crisis is causing us to not save lives. So hence we went to court and said that these particular areas or these sectors of our society, they need to have electricity, because at the end of the day, even with police stations, people are getting raped, but their labs aren't functioning because of load shedding. And the next thing, you find those cases are being thrown out. I can give you an example right now in KSD, in Mapuzi College, where students have been victims of rape, but nothing has been done. The perpetrators are still roaming the streets because there could not be any verification of the rape kits and so on, because the labs are saying that we do not have electricity, and therefore this will take longer than expected while perpetrators are roaming the streets. The schools, but remember that South African government provided electricity, stable energy electricity for the Rugby World Cup, of which was very strange for us, but they could not provide sustainable energy for our children to study as they're going to their grade 12 and so on. So this is a victory for all those people, not just these sectors, but the South African community at large.
So the judgment in respect to Part A of the UDM's application found that in simple terms, I read, the government had been warned and had accepted that it will run out of generating capacity by 2008, which had happened. And in the 15 years since then has failed to remedy the situation. Added to this is the detailed evidence of Eskom's acting group executive generation regarding catastrophic failure suffered by both Kusile and Midupi, which contributed substantially to the overall lack of generator capacity. Now, you had wanted all public health establishments, all public schools, as well as the South African police services to be cushioned. South Africa has since received a consignment from China. Does this go some way in satisfying the party?
As a judgment in the opening, the judge spoke about what you've just alluded to or read right now. It is really disheartening to have a country that has been warned over time about this crisis, and therefore they decided not to look into it or not to do anything about it. Even with the consignment from China, we do not know whether it's going to go to which minister's house, and then it's going to be there, because you remember during COVID there were Jojo tanks that were provided, and then the next thing we find them in councillors' houses in numbers. And right now we do not even have the faith, as much as we are happy that the courts is forcing the government, of which it should not be like that, whereby our people or us coming and going to the courts or even writing petitions or going to the streets to force the government to do what they are mandated to do, especially what they have promised that they are going to do, because the provision of sustainable electricity or energy, it's one of the promises of the ANC government since 1994, and they have been warned that that is not going to be from 2008, but but they still didn't care because all they wanted to do, all the money that was supposed to go to Medupi for maintenance, for building new power stations, had to go to their pockets and their big bellies. So right now, the consignment is coming from China. Yes, we welcome it and we are happy about it, but the question is, are there monitoring and evaluation plans in place? Is there consequence management if that consignment does not go to these particular, sectors such as police stations, schools, and so on and so forth? So we have a government here when even if they do receive donations, you'll remember during COVID that we had a 500 billion that we do not know where it went, and people kept on dying like flies and so on. And right now, the SIU is busy with investigations of COVID-19 related funds, of which the president himself promised South Africans that there will be no corruption. So we do not even know, even with this one, as much as the courts have vindicated the UDM and others, but at the same time, we're saying with the consignment coming from China, who is going to look after that? Who is going to dispense it? Where is it going to? Are we going to have the same supply chain management issues that we had during COVID and years before that? So we're still looking into that, and we are going to be watching them like hawks.
Okay. As you mentioned, you abandoned Part B of the relief you had sought, but the court document reads, in Part B of the UDM's application, it sought extensive relief. This included a declaration that the President of the Republic has failed to respect, promote and fulfill the rights in the Bill of Rights as required by Section 7.2 of the Constitution, a declaration that the failure by Eskom and other organs of the state had violated the rights of the applicants and the persons whom they represent, including the South African public at large, to various constitutional rights, including those of equality, dignity, life, freedom of economic activity, healthcare, sufficient food, water, the rights of children and their rights to education. Remedial relief was sought in the form of a direction to Eskom to report to the court what steps will be taken to ensure that there is uninterrupted and reliable supply of electricity to eligible users, and what steps will be taken in the short and long term to end load shedding within a reasonable time. As already mentioned in the introduction of this judgment, in addition, the UDM also sought review of NERSA's decision of 12 January 2023. We'll get into NERSA in a few moments, but just remind us again why you had abandoned Part B, because at the time you even had the presidency coming out to berate the party specifically, saying that you wasted taxpayers' money as they had already prepared to respond to you. So given this, why did you abandon it? Please remind us.
When you are fighting a fight and you know that, one, you need to go with what's going to work at the time. And what we had decided to say that what we set as an executive committee of the party to say that let us not fight all battles at once. This is a battle that is ongoing. Just for this one, we need to win the Part A of it, and then we are going to come after that. Because when we consulted with attorneys and people who are experts within the energy spaces, the advice that we got, and we thought, okay, let us go with this advice for now. Let us win these battles, bit by bit. But at the end of the day, because we are dealing with a human rights issue here, and we still believe that even though we have abandoned all, we have decided to stop Part B and not go forward with it. But at the end of the day, it does not mean that we do not care of what we wanted to do in there. And also, we're known through these advices that NERSA is not, going to be entertained, as you have seen in the judgment as well, under the DA and others. So it would have been a futile exercise for us to carry on with that. But as well, you'd remember that the Minister of Electricity as well came out and said that on the 24th of December, there's going to be an end of load shedding, of which we do not believe that. Thank God the courts have given him up until the 31st of January for him to do what this judgment is enforcing them to do. So there's a grace period there for him, and he should thank the courts for it, because we are still going to hold him accountable for the 24th of December that he had declared himself in one of the interviews in one of these television stations. So with Part B, it is not all lost and gone. It is still within the party lines to say, now we are done with Part A. But what then do we do? What advice do we sought after this? Is the government going to do exactly that we expect them to do, which is nothing, so that we can go forward with Part B? And then I think at the time it won't just be Part B; it will be a fresh, case. But then if the government says that they wasted taxpayers' money, it's because they want to brush us in the same, with the same paint as they are. They were not ready to do that, because at the end of the day, why would we even go to courts to enforce them to respond to us? They should not have responded to us. They should have, done what they should do, mandate, give service delivery to our people, and that's how far it goes.
Are you disappointed that the courts didn't entertain the NERSA tariff determination?
As I've alluded to saying that we're expecting it, that it is not going to be entertained, or we are going to get a verdict which is not favorable to us. But it is not all lost, because remember that NERSA and them having to increase electricity tariffs. It's something that we have been very vocal about in Parliament, and we believe that even if the courts did not enforce them to do to decrease, but there's still some room even in Parliament to maneuver that. However, we are still going to come back if we feel that now our people are feeling the pinch. The inflation is high, fuel prices are high, everything is, the price of bread, the price of eggs and potatoes in South Africa is extremely high, and it's entrenching our people into poverty. Even those who are trying by all means to afford electricity, they can't because of NERSA's trying by all means to bail out Eskom out of their mismanagement and negligence. And we cannot fold our arms and sit back. But if it continues in that direction, I know for a fact that we are going to go back to the courts to enforce them again as a separate application altogether, to say now we are focused on NERSA and the increase in tariffs and so on.
Thank you very much, sir, for your time this morning. UDM General Secretary Yongama Zigebe.